making the time to join this conversation today. We're going to be talking about data privacy and the importance of getting ready for the implementation of Jamaica's Data Protection Act. We've been talking a lot over the last maybe year or so about data protection laws and data privacy and privacy versus protection and what that means for organizations. And that's been since the passage of the Jamaica's Data Protection Act in 2020, in June of 2020. And this really followed the implementation of the General Protection, GDPR, the General Data Protection Regulation coming out of the EU. And we'll talk a little bit about how some aspects of Jamaica's DPA have been modeled from the GDPR. So today it's meant to be a really informative and interesting conversation. And joining me to have that conversation are three experts in the area. We have on the webinar this morning, Joaquin Murray, who is the Chief Technical Director for ICT in the Ministry of Science, Energy and Technology. We have Grace Lindo, who is a partner at Carter Lindo, attorneys at law, and Andrew Nooks, who is the Director of Efficiency and Growth at Symptai Consulting. My name is Andre Palmer, and I'll be a moderator this morning. I am the Director of Research and Engagement at Symptai Consulting. Before I get started, what I'd love to do is to invite our panelists, Joaquin, Grace, and Andrew, just to give a quick 30-second introduction and talk a little bit about who they are and their areas of expertise. So Joaquin, do you want to kick us off?
Sure. Morning, everyone. So as was said, Joaquin is the name. I have been working in the field of ICT since 2003, and that would have been when I was called to the Jamaican bar. And over the last 18 or so years, have been exposed generally to the areas of telecommunications, electronic commerce, intellectual property rights, cybersecurity, and data protection. I am the holder of a Master's of Law in Technology, Media and Telecommunications Law from the Queen Mary University of London. And I've been for most of my life in the public sector, both as a technical director, so to speak, and as a legal officer. And that's me.
Great. Thank you so much, Joaquin. Grace.
Good morning, everyone. My name is Grace Lindo. I am a commercial and intellectual property and now technology attorney at law at Carter Lindo, which is a fairly new law firm started here in Kingston, Jamaica. I have been in this area for a few years since 2007. I've been an IP lawyer since then, and I've been drawn to technology since doing my own master's in 2015, and certainly to data protection since then too, because I see this as a growth area, certainly if we want technology to become the centerpiece of our economic expansion. And I also am the training partner with Symptai, and I'm proud to be a training partner with Symptai in respect of their IAPP courses, CIPM and the CIPPE. I think it's going to be very important for technology practitioners to know this area and to become certified, whether they are looking to become data protection officers or just getting their organizations up to speed with data protection. Happy to be here.
Great. Thank you. Thank you so much, Grace. I know we go to the thorn among the rose, Andrew.
I don't know why you have to go. Why you have to go there now? Why you have to go there? Good morning, everybody. Okay. I'm Andrew Nooks. I'm a director with Symptai Consulting. Been in the technology space for over 30 years, and the transition to information security and data privacy more recently, back in 2018, when the GDPR became front and center because of its far-reaching impact across the globe. This morning, I'm hoping to share with you some combined experience from my journey as a technology practitioner, as a cybersecurity expert, now data privacy and protection expert. So, I want you to relax. The panel here, I think, is knowledgeable. We have two lovely ladies who are even more knowledgeable than I am. And, we hope to share with you some insightful perspective on the Data Protection Act and how it can impact you and your organizations. So, enjoy.
Great. Thank you so much, Andrew. And I did say that we had an extremely qualified panel of presenters, guests this morning, and they've just verified, what I'd said initially. All right, great. So let's get started, and I'd love to kick off with Joaquin just to talk about the importance of the Data Protection Act. What was sort of like the driver behind the implementation of the act, and what does it mean for Jamaica?
All right. The government of Jamaica, around about 2007, started this drive in relation to ICT. And I think there was a recognition generally that if we're going to push electronic commerce and ICT in the country, then there had to be a suite of legislation in place to support that framework. And we would have started off as a government with the Electronic Transactions Act. We would have gone then to implement and promulgate the legislation in relation to cyber crimes. And then the last bit in our minds, or the last piece of legislation that would have been critical would have been the data protection legislation to kind of pull the things together. So around 2015, we started to work on the data protection bill. And I think persons are fully aware that we went through a long haul of trying to get that on board. In the midst of our review, really, or the preparation rather of the bill for tabling in Parliament, GDPR came on. We would have had to take some time to revisit the legislation in light of that piece of regulations coming out of the EU. And we have culminated all of that long process, long walk, with what we have now, the 2020 Data Protection Act.
No, go ahead.
No, so it's significant in that what we had before was discrete pieces of legislation which spoke about confidentiality and privacy, right? But we didn't have a comprehensive piece of legislation that treated with, that would define the principles for processing personal data. And of course, proved to be a guide for both public and private sector with respect to how data is processed. And so the Data Protection Act is significant in that sense, because while it is that there are legislation with provisions that treat to protect the privacy and confidentiality of personal data, it wasn't fulsome, and it wasn't comprehensive.
Excellent. So, and I'm glad you actually touched on that, because at the heart of the act is really a focus on the rights of the individual. So you as an individual and the owner of the data. So what does the act really mean as it relates to the protection of rights for individuals, the data subject, if you will?
All right. So it's a Data Protection Act, and I want to make that point. It's we call it sometimes a Data Privacy Act, but it's a Data Protection Act. It really seeks to protect citizens, individuals who will have to do business in Jamaica. In the provision, what would happen when their data once it's provided to anyone, particularly what we call in the legislation data controllers. And what it seeks to do is to enable the individual to be able to ensure once that data is passed, because you're not protecting privacy now. Once you hand it over, it's kind of like you're giving it or entrusting it to somebody else. And the idea here is that once you've entrusted your data, which is your own personal data, then that person now has an obligation to ensure that it's protected as best as you can. And so what the legislation does is that it establishes at least 6 sets of rights for data subjects, to include the right to access, the right to data portability, the right to what we call rectification, the rights of rectification. There's also the right to ensure that your data isn't processed for direct marketing. There is the right also in relation to automated decision. Andrew laughs. The right in relation to automated decision taking, and the rights to prevent certain types of processing. So there's 6 rights that have been established within the legislation to protect citizens.
Okay, so a lot of people may be thinking there are lots of laws in Jamaica, and we've seen the passage of many. But then sometimes these laws can be seen as a dog with rubber teeth. So it's hard to enforce. So I mean, the Act provides for the establishment of the Office of the Information Commissioner. So perhaps you could talk to us a little bit about what that means in relation to enforcing the Act and ensuring that the rights of the data subjects are actually protected.
Right. So any regime that speaks to data protection has to have an enforcement element, and our legislation is no different if you look at the legislations across jurisdictions. And so, as you rightly said, there is an office established called the Information Commissioner, and that office is responsible for compliance with the legislation. There are some other things that it will do. The office will advise the minister and will engage the public. And I say public because I mean both citizens or individuals, data subjects, and data controllers with respect to the implementation of the Act and how the Act functions. The office is empowered by virtue of the provisions thereof to issue enforcement notices, information notices, and to take action. In fact, the office will have powers of entry onto premises and to summon persons in terms of witnesses. So the office is empowered. In fact, what is interesting is that when we were passing this piece of legislation, there are concern about the power of the office, but it is empowered to enforce the legislation and to take necessary action, to the point where further to discussions with the Office of the Director of Public Prosecution, it can even prosecute. So, of course, there are heavy fines, some for body corporates to the tune of 4% of their profits, or revenues rather. And we anticipate that persons will realize that the intent of Parliament is to ensure that persons comply.
Excellent, good. So there is a period allowed under the Act for until it becomes enforced. So can you describe for us the process of now operationalizing the Act? So it was passed in June of 2020. So it's almost been a year. So what happens between then, the passage of the Act, and to the point when it becomes enforced?
Right. So Section 1 of the Act basically says that the Act shall come into operation on a day appointed by the minister. And that particular section also notes that different days may be appointed in respect of different provisions of the Act. So what we are doing now as a ministry is that we're making preparation for provisions in relation to the establishment of the office to come into force first. And what will happen is that when that appointed date is announced, then data controllers will have at least 2 years to comply with the provisions of the legislation. So as it is now, we are in the process of establishing the office. Persons might have seen, advertisements in relation to the recruitment of the commissioner and a deputy, etc. We're trying to fill critical posts and positions, and once certainly the information commissioner is appointed, and that appointment takes place, the appointment is done by the Governor General after consultation with the Prime Minister and the leader of the opposition. And once that appointment takes place and some other critical positions are filled, then the minister will move to set the appointed date. And as I said, persons will have 2 years from that to begin to ensure that they're compliant.
Okay, great. So like GDPR, I guess the implementation period presumably allows organizations to really get their houses in order in preparation for the Act becoming coming into effect. Can you speak to any kind of assistance, technical or otherwise, if there are any, that the government may be providing to help organizations get ready for the implementation?
Well, no, not any kind of technical assistance. What we're doing, though, is we're ensuring that we have a properly functioning office with which data controllers and data subjects begin to engage. We anticipate that once the information commissioner is named and the critical positions are filled, then they will busy themselves with getting their own shop in order. And then, of course, putting themselves in a position to be able to guide persons as to their own compliance and preparation for compliance with the legislation. We expect that they would be issuing guidelines and directives and simplifying the legislation. They would embark on a public education and awareness campaign so that persons can become aware of the provisions of the Act, their rights and their obligations under it. So what we're doing as a ministry is geared towards that. But once the office is operational, it's really the office's functions in terms of the compliance.
Just if I may jump in,
sure.
Andrew,
is that saying that the government now is putting in the dentures into the privacy law, replacing the rubber teeth with dentures so that it can actually bite?
Absolutely. Absolutely.
I like that analogy.
And the truth is, it is an independent body, and I don't want persons to see it as something that, it's a government organization. It is a regulator in effect. And so, as I've said before, with tremendous amount of powers to the chambering of others, but that's how it is.
Great. And I'm glad you actually mentioned the point that it is an independent body that is free from the influence of all of the other actors, because I think that is actually an important point, just to highlight the integrity of the office that we're looking to establish. One final question, Joaquin, before I bring Grace into the conversation, and this may be putting you on the spot a little bit. Do we have a timeline for appointment of the commissioner? Do we know when such a person will be appointed?
Well, we've actually gone through the interviews, identified persons, and by persons I mean the deputy, a potential deputy, and a commissioner. And that report will go off to the Governor General for his consideration. So it really depends on what he says. But it's in training. Right, it's actively in training. We're actively, we're moving on this. And I think persons would recognize that there's an imperative around it because of the implication for other pieces of legislation that need to come on stream, that can't come on stream until the Data Protection Act is fully operational.
Excellent, good. No, that's certainly good news. Great, thank you so much, Joaquin. I'll bring you back into the conversation a little bit later on, but I now want to turn the focus of the conversation slightly to look at some of the legal ambits of the Act. And for this, I bring Grace in. So Grace, this is the 15th piece of privacy legislation in the Caribbean, Jamaica's Data Protection Act. So some would probably say that we're a little bit late to the game. Can you speak to how similar or different the Data Protection Act is compared to GDPR, for example, or other pieces of legislations that may be out there?
Right. Very good question. I think, when you look on our piece of legislation here that we have proposed or will come into force shortly, it is largely based on what comes out of the European Union, or what has come out of the European Union since the 1990s, because GDPR is, I think, the third iteration of a privacy law out of the EU, and we're pretty much following the same framework. GDPR, I like to call it privacy 3.0. I think we have reached privacy or data protection, rather 2.9, if anything, or 2.8. We're very similar. There are some minor differences, and the rest of the Caribbean has followed the European Union route. We are not looking at a sector-specific type of data protection law, which is what you'd find in the United States. We're looking at a wholesome and fulsome data protection piece of legislation. There are differences. GDPR did take quite a while and quite a lengthy time in terms of looking at how it would be best fit for all European Union countries. And so there are some differences, primarily when you look on how they treat minors. And I don't think that we went astray in terms of that, but certainly in the European Union, they do look at the information society and the ability of minors to give consent even when they haven't reached the age of 18. And that's one thing that they took into consideration. The Jamaican government also chose to give data protection rights to the deceased. People have been deceased for 30 years.
Interesting.
Interesting, yeah. I am still to look at the Hansard in respect of what led to that decision, and I'm sure I'll have discussions with Akin thereafter. But I must say, as someone who will act for the companies which need to be in compliance, it raises the bar. And I, for instance, the other day I had to speak to some doctors in respect of their compliance, and certainly they are it would be within the category of persons who know how to protect the data of deceased individuals. That's a lot of work. So, so that's one difference. Apart from that, though, GDPR, when you look at it, is, of course, our European level type of law, but it did allow, and it still does allow, particular countries to get more granular in respect of how they implement their laws. For instance, human resource and employment related data. Member states are allowed to go not astray, but certainly get a little bit deeper in terms of details regarding the protection of that sort of data. We're a small jurisdiction, so we have categorized HR data, human resources data, into sensitive data to a large extent. So, it's just a different type of legislation. GDPR comes out of continental Europe, so you'll see some sort of civil law influence there, whereas us in Jamaica and rest of the Caribbean, we're common law people, so the type of drafting is different. But it will serve as a very good example for us in implementation. That's that much I would say.
Got you. No, thank you. Thank you, Grace. And you've talked a little bit about sensitive data or sensitive information and personal information. Can you talk about what the distinction is between the two, either sensitive data and personal data, and give some examples of each?
Sure, no problem. So personal data is anything which makes you identifiable. And, we like to give numerous examples of this, especially examples that people don't normally think of, like your IP address. Our internet providers do have our IP addresses, and it makes us identifiable as individuals. So it's anything which makes us identifiable, which can be a diverse set of variables or set of things. Sensitive data is more personal. It is race, sex, gender, same thing, biometrics, anything in relation to the individual's health, for instance, very sensitive to the individual's use in the public domain. And the Act and the law requires us to treat sensitive data at a particular level. The threshold for processing that data is, of course, much higher. You need consent. And for persons who will be in this area as practitioners, the sort of assessment and sort of audits that you will do when it comes to sensitive data will be much higher at a much stricter level than ordinary personal data, for want of a better term.
So is it fair to say, because a lot of companies said, well, we don't really collect lots of information, or we don't collect personal information, but based on those definitions, is it fair to say that every single entity collects some kind or some amount of personal information, if not necessarily sensitive?
I think every entity or most entities would have collected some sort of personal data. I mean, unless you're doing, I can't fathom B2B business, business to business in which you don't have any personal data, which in this day and age, that's almost unlikely. Well, you guys as technical folks will tell, because when you do your data mapping, do you see anything which is not personal? I doubt it very much. Yeah. So very few companies, I think, would be exempt from the Data Protection Act.
Yeah. Not just that, but it is.
Andre, if I could jump in a second.
Sure, Andrew.
From the perspective of companies, though you may not be collecting data to do your business, if you're a B2B, as Grace mentioned, you may have staff. And a lot of times we're always looking outwards to see, what we're bringing in, but we're not looking at the data that we're already having by virtue of just employing people.
Mm-hmm.
Yeah, no, that's an excellent point. And I was just about to ask that particular question just around, because Grace had mentioned the HR component. Mm-hmm. So you're collecting personal information on your employees. So that obviously you fall into the category of those companies anyway. I want to switch gears a little bit and just look at the difference between a data breach versus a data leak. Mm-hmm. Again, this is coming out of this idea that organizations feel as though if data gets out because of an error on the part of an employee, for example, then it doesn't carry the same kinds of penalties as if the data got out from some kind of malicious attempt from an ill-intended actor. What are some of the differences between a leak and a breach?
If any. If any.
Right.
But let me first say that a data leak isn't really defined under our act. It doesn't make reference to the term data leak, but it is something which in your world, it's a terminology which is used. And so I can understand why the question even is raised. And one of the standards that we will be required to put in place if you are a data controller, which is almost all of us and all companies, is adequate technological or appropriate technical and organizational measures, which means you must have your technology up to scratch to prevent any breaches or leaks. And if that is contravened, when I look on the act makes a requirement or has a requirement for you to report contraventions and breaches. And so to my mind, there will be some sort of need to report these breaches or leaks once it is that the data subject's rights, and Joaquin made a very good list of what those rights are. Once it is those rights are contravened in any manner, there will be some requirement for reporting. That's my reading of the act.
In the technical space, though, and Grace mentioned the technical space, a breach usually is termed from something that is happening from outside coming in. Really, in most cases, malicious or intentional attack from outside. And a leak usually is from inside going out, whether intentional sharing data with an unauthorized source, or inadvertently sharing data with an unauthorized person. Say, for instance, a mistake in an email that would go out to persons who it was not intended for, that reveals the information about persons. So in looking at that, the act, whilst it didn't speak to leak or breaches, it spoke about unauthorized access. And in some of the data protection and privacy laws, it also talks about disclosure of information, and the leak or breach could come under those terminologies. I'm no attorney though, so I will stand corrected by Grace and Joaquin in that sense.
But you are a technical expert who understands data protection laws very well, Andrew.
Right. The reference is there in the act to accidental loss. And so that's where I think if we are going to construe, a leak as anything, whether internally, on purpose or not on purpose, accidental loss, I think is a contravention of the act. It's a contravention of the 7th standard. And so that would require both reporting and could lead to a fine as well.
Right, and I might just jump in here a little bit. One of the things that the legislation does, which we haven't done in any piece of legislation before, is to require disclosure of that leak or breach to the data subject, because we know that some organizations have a habit of keeping things under the wrap, and they have to tell the data subject what it is that has transpired, and then they would have to notify the commissioner within 72 hours of that, them becoming, of course, aware of it.
And that requirement is in place irrespective of whether it is accidental or otherwise.
Absolutely, because as Grace would have indicated, accidental is unintentional. If you get into the break it down a little bit more.
Got you. Great, thank you for that contribution, Joaquin. Grace, I have a couple of questions, but I want to pause really quickly just to engage our attendees a little bit. We have some poll questions, and based on the conversation so far, so Joaquin would have talked about the technical framing of the act and the intention behind it. Grace is talking about some of the legal components and a little bit more of what some of the salient clauses in the act really mean. So I want to ask the attendees on this webinar, is your organization prepared for the Data Protection Act, or for the implementation of the Data Protection Act, rather? So I believe DeAndre will throw this question up. So just, click yes, no. There are a couple of other options. And then at the end of my conversation with Grace, I'll go back and look at the results from that specific poll. Grace, just to continue the conversation. So a big part of the act is this idea of consent. So what does it mean, and what does it require organizations to do or to do differently in obtaining and getting consent of data subjects?
Right. So consent is fairly well defined in the Act, freely given, capable of being withdrawn by the data subject. This is, I think, consent is, for me, one of the bases of data protection. We have realized, and the world has realized, that you can't get consent for processing everything, but you certainly need consent for certain types of data. And as we've said before, sensitive data does require that level of consent. Now, when you think about it, practical terms, when you talk to clients about, well, how do you get consent for processing? You know, everybody thinks, well, do I have a consent form? And that doesn't really work in the e-commerce age. You know, it doesn't work when you're building an app and everything is, you know, very nifty. You don't know if this person is a minor when you're ticking the box as to being age 18 or so. So it does require, I think, consent and privacy by design, which I think Andrew will be speaking about later.
Right.
How do you make sure that the system itself leads the individual to, one, read this long or perhaps even a very summarized but appropriate summary of the end user license agreement or the privacy notice? How do you make sure that the system that you're looking online doesn't encourage a person to just click and go to the next page because they want the product? So I think, and going back to selling what you're doing, your IAPP training, that's what you need to learn in order to do a system which is built, or to create a system which is built on the foundation of data protection, knowing how to design with privacy at the very central part of your technological framework.
Wow. So there are a lot of things to consider, and there obviously needs to be someone in the organization or aligned with the organization that is keeping an eye on all of these things. And the Act speaks about the role of a data protection officer, a DPO. So can you talk a little bit about the role of the DPO as defined by the Act?
Right. So a data protection officer is a compliance officer for the data controller. The data controller is a person who controls how your data is being used within the organization. Even if they farm it off to a third party to be used or to be processed rather, they're the persons who say, this is how things must be treated in respect of this data. And that person, corporate or individual, will need to have a data protection officer, a compliance officer. I'm going to draw parallels to the compliance officer under our money laundering legislation. All our banks have a compliance officer now. It's required by statute. And like that compliance officer, the person must have some level of independence, because the person is more than just a point person in-house. The person is sort of or not sort of, but it is a whistleblower. And for us in Jamaica, that will be a tricky one to think about. I mean, it's already a problem within the POCA framework, the money laundering framework, but think about a whistleblower when it comes to data protection and saying, okay, something has gone wrong here, they're using this data wrongly, and I said it shouldn't be. I did a data protection impact assessment, and they still went ahead. You know, hands up, something is wrong, Mr. Information Commissioner. My company who employs me and pays me is going down the wrong road. But that's what we'll be getting with a data protection officer. So that individual also will be required to give reports to the Information Commissioner, I believe annual reports as to how the data is being handled. And of course, if there is a breach or leak, that's the person who will channel that information and do that reporting. It will be a heavy hat to wear. Persons will be particularly trained and will need to have knowledge of the laws, but it also will need a certain type of personality, I think. And I think organizations need to think about those two facets when you're choosing the data protection officer.
So to that point, does the data protection officer have to be someone within the organization?
No, the data protection officer doesn't. And because the person will be a whistleblower, if you are within an organization where you think a conflict of interest may occur, it may be useful for you to outsource. And that's quite fine when you look at the statute.
Okay, got you. And the other part of that question is, will every organization be required to have a DPO as well, or are some organizations exempted?
Yes, some organizations will be exempted. I believe persons and organizations which deal with sensitive data will be required to have a data protection officers. Organizations which deal with a large scale data sets. I'm unsure as to how that is properly defined in our Act, but I look to guidance from our regulations on that. And also public authorities will need to have a data protection officer. The minister can grant exemptions, and I believe there will be exemptions coming out in fairness. right? If even for a certain time period, I think there will be exemptions. NGOs, for instance, and some not-for-profits will be exempt from having a data protection officer.
Okay, great. Thank you. Thank you so much, Grace.
Mm-hmm.
I'd love to now bring Andrew into the conversation so that we can expound the talking points around what will be required to become compliant with the Act. But just before I do that, you would have seen 3 questions in the poll. Initially, we said we were just going to ask 1, but there were 3. Does your organization have a data privacy officer or someone qualified to act in that role? And 3, has your organization ever performed a privacy impact assessment? If you've answered all 3, that's fine. We'll reveal the results closer towards the end, and then we can talk about that a little bit more. But if you want for those to be relaunched, we can also do that as well. So Andrew, we've talked a lot about the law and what the law says. Now, as it relates to implementation of the Act, what are some of the things, or maybe 3 things that organizations need to think about when looking at developing a data privacy program?
I think to know this, I'm just going to encourage everyone to register for one of the courses Andre has been advertising. So, I mean, that's my response to that. No, in all
if it were only that easy.
Yeah, I'm sorry to get out of that one. But typically, I usually start with any program is to know yourself. And by this, I mean, know your organization. Ensure that you have a fair understanding of your business, you know, where your business operate, what are your business processes, what data you collect to support those business processes. And you also have to know your external environment. The laws will be applicable based on the jurisdiction in which you operate. And when you are operating a business that's in the public space, that is like a flat world operation, it has no borders and limits. So you have to consider these things when you're launching your business. The other thing is you have to implement controls, and those controls could be administrative as well as technical. From administrative controls perspective, it would be notification, gaining consent, developing your internal policies. Technical controls could involve putting in data loss prevention systems, right?
Mm-hmm.
So really, what you're trying to do is to ask what data is being collected about your customers, where is the data collected being stored, how is the data being processed, who has access to the data, which countries do we operate in, and then you review your existing controls, all your forms, all your contracts of consent, data sharing clauses, determining who is processing the data, because there are times when we're sharing data and don't realize. When we use cloud infrastructure for argument's sake, we're maybe placing data in a jurisdiction that you don't necessarily have control over. And the Data Protection Act speaks about, in standard 8, I think, speaks about the sharing of data and ensuring that data is shared in a jurisdiction that has similar laws to that of your own. And and that's me putting it in my own terms. So those are some of the things to look at. I know it's a bit more than 3, but those are some of the things to look at.
No, that's fine. So it sounds to me like there needs to be very deliberate thought going into developing a kind of data privacy or data protection program. And we've often heard the term privacy by design, and Grace mentioned it earlier. But what does this mean in light of all that you've said around getting ready for the implementation of the Act, and how do organizations implement and practice a privacy by design approach?
Privacy by design, typically, as it suggests, is building privacy into the DNA of your operations. So from concept to implementation to destruction of data, you have to be considering privacy. So it speaks about, privacy by design speaks about lawfulness, fairness, and transparency, purpose limitation, data minimization, on proportionality, accuracy, storage limitation, integrity and confidentiality, and accountability. And if you look at these principles of privacy by design, it maps very nicely with the rights of a data subject as outlined in the law, and to some of the standards, the 8 standards according to our Data Protection Act. So, you know, when you say, for instance, you're rolling out a new product, a lot of persons will wait until we're about to launch, then they start considering privacy and protection. The privacy by design says, the moment I conceptualize this, I have to be thinking about the data I'm going to collect and the impact that it may have on the persons who own that data. And, you know, to ensure that that is considered at that concept phase. When we design, we have to design to ensure that we can respond to a data subject request for their information and all that. You know, just some of the things that we have to consider. And privacy by design assists an organization in building that from the ground up.
So, you know, so it's dawning on me, Andrew. So Joaquin talked, well, both Joaquin and Grace talked a lot about the legal components. Grace, to an extent, talked about some of the compliance and governance components as well. Sure. Here you are talking about some technical components. Sure. So where in the organization should a data privacy function reside? Is it legal? Is it compliance? Is it IT? Is it the office of, where does it reside?
Listen, you see this question is really it's really a tough one for many organizations, because it will depend on the size. A lot has to do with your organization and the size of your operations and everything. So if you have a very large organization, you know, based on a research by the IAPP and Ernst & Young, they would say 50% of the respondents in that survey said that legal would be the best place for it. Others, 22% says it comes under regulatory compliance. About 17% would say it would be have its own department or division, which is privacy and data protection. In some places, they'll put in information security. And we find that a lot of our local entities are looking to information security to provide a great assistance because of that protection bit of it. But, you know, always caution persons that there is much more to the law than just the protection. There is the use, the consent, the sharing, you know, to name some of the things that we have to be mindful of when we're talking about the data protection. Where things overlap would be from the perspective of confidentiality and integrity. That's how it overlaps with the protection or the security bit. In some organizations, it's corporate ethics, and some very few organizations would be information technology department. But again, it will depend a lot on your operation. And, you know, as Grace mentioned, the whistleblowing mentality and the independence, you have to determine that wherever you place this, the persons looking at privacy will have certain level of independence in going about their duties.
Got you. So it really sounds as if it is a cross-functional and multidisciplinary type of approach that is needed. And I think it is fair to say that data privacy and data protection is everybody's business.
Yeah, it definitely is cross-functional, Dre, because it will impact most of our organizations. Most of our departments in organization, and one of the department that is always impacted is marketing, because marketing uses a lot of data and they send out a lot of requests and stuff like that. You know, I mean, Andre, you know, you do business development, so you know how that goes. Yes. Then you have human resources that collects data for the internal people, and that is often overlooked, as I mentioned before.
Got you. I want to invite some questions from our attendees, but before I do that, Andrew, I just have 2 more questions for you. You've worked in the data privacy and security space for a long time, and you've worked with a number of clients on helping to build and implement data privacy frameworks to help them to understand whether or not they're ready for the implementation of the act and what they need to do to get to that point. Can you talk to any examples that you may have come across around either data leaks or data breaches and the implications for organizations, either financial or otherwise?
Data leaks and breaches. I mean, we have seen examples in our public space over the last 18 months of organizations that have faced challenges that could have led to exposure or disclosure of information. Typically, the cost of a breach, it's very difficult to quantify, with the exception of the fines that may be levied from a commissioner's office, or information or data commissioner's office. But then there is loss of revenue because of your reputational loss. There are other fines that can be levied onto you. Let me jump back a little bit. 4%, and I want this to sink in, 4% of your global turnover, your global revenue. It's no mean feat. I was looking at this for an organization, and when I looked at what 4% was for their revenue, it would have wiped out the budget for their information systems department. And in today's world, wiping out a budget for information systems department is almost like wiping out your business, right? So if you let that sink in, but then you have reputational risk. You lose your customer trust. You'll lose potential, existing and potential business, and your the impact on your business relationships could be large. But it also has implications for the individual. Persons could go through religious persecution, having exclusion because of race or sexual orientation or even our gender. There's political persecution, identity theft that could lead to reputational and financial damage. There's financial damage directly because persons can now open, take out credit cards in your name and run up a hefty bill. And then you have things that emanates from that, emotional distress, stress generally, and that cause a whole other set of challenges. So the cost to breach, some part of it, as according to the Act, is quantifiable. In others, it would be qualitative and subject to the mathematical experts to try to put a value to that.
Yeah. No, I mean, those are lots of things to think about, especially when you list out the implications for both the individual and the organization in that way. It really highlights the importance of ensuring that we comply or get to a place where we can comply with the Act. So my final question is really just around what organizations can do to prepare their staff and themselves to get to that point. And I want to talk about the training courses that are being offered by Symptai Consulting in partnership with the International Association of Privacy Professionals, IAPP. So there is the CIPM, CIPT, and CIPP. Can you just talk to the three courses and what they actually mean, and also a little bit about the partnership with IAPP?
Yeah, sure. The courses, Andre mentioned CIPM, CIPT, CIPP. CIPM is a Certified Information Privacy Manager. And this course, it uses effective strategies for developing and implementing a robust privacy program. It also helps you to be able to integrate privacy requirements into organizational policies and procedures, and to create awareness, to bring a culture of privacy across the organization, because some organizations are going to require some kind of paradigm shift. Every time you pick up a piece of data, every time you work on a piece of data on your system, every time you take your laptop or your phone out with all the emails that you have on it, you have to be considerate of the implications for the individuals whose data you're traveling with. It helps you to effectively plan for and respond to incident and data breaches. And a funny thing about this is the way how we respond to a breach can have or an incident can have a very positive or negative effect. And I've seen examples in the recent space of where the handling of incidents, has caused a lot of debate across the data privacy space. Then we have to look, it helps you to determine what to monitor, what to measure, and how to analyze and audit the performance of the privacy program. So it looks at topics such as governance, applicable laws, data assessments, policies, data subject rights, and so on. From the CIPP perspective, the CIPP helps you to recognize the foundational elements of privacy, embedding privacy in technology, and it speaks a lot about privacy by design. It describes the fundamentals of privacy as it relates to the privacy technologist, and this is the person who is going to be the technology person or the privacy analyst.
That's the CIPT.
This is the CIPT that I've jumped to, right?
Mm-hmm.
It helps you to identify the risk of privacy. It looks at technology and the different challenges that technology, especially when we're talking about Internet of Things and apps and all of these things, what that brings. We talk about surveillance, we talk about things like Jamaica Eye, and it talks about the implication for some of those things as we go through the course. So it assists an organization team member to add value to a conversation about how the organization operates and implement privacy. The CIPP has several versions to it, and the one that we focus on is the European Union's, and that's primarily because it maps very nicely to what we do in the Caribbean. As was mentioned before, our laws are basically drafted along consistently, for the most part, with the EU GDPR. So this walks you through the laws and the implication of the laws of the region. It talks about the whole business of data sharing, talks about data subject rights, the data controller, and basically walks through aspects of the law. And what we do differently in when we offer the CIPP and the CIPM courses is to ensure, though these courses are based primarily on international standards, we bring it home based on our experience. We bring it home to map to our local and regional experience, and which is why we have partnered with Carter Lindo to leverage Grace's experience in the legal fraternity, not just in Jamaica, but across the region. The partnership with IAPP was very important for us because we wanted not just to be focusing on give a certification that is going to be tied down to Jamaica. We wanted to give you a global experience because, as the GDPR has proven, privacy is not about local. In today's e-commerce world, data and where data resides, it is a global thing. And especially when we're looking at cloud services and all of that. So we have to understand the entire landscape, and which is why we move for international flavor and the partnership with the IAPP, who has been very, very supportive. And if you become a member of the IAPP, which is what these courses also offers as a part of your course subscription, you will be exposed to a wealth of other information about privacy across the globe.
Great. Thank you so much, Andrew. Couldn't have said it better myself. We just have about 5 minutes to go, and I really want to get a few questions in. So while DeAndre gets ready to bring up the results from the poll questions, we have a question from Ian Key, and so it reads: in relation to the AMBER breaches with COVID-19, the COVID-19 travel data for visitors, what sanctions could be levied against the government or AMBER in this context? And is the fine per breach or per instance? What if the breach was an advanced persistent threat and we're just now discovering it? What in that case? So I'm not entirely sure who wants to jump in first. provide a response to this particular question.
Well, that question has several different components
It
to it.
does. It does.
I'm going to defer to Grace or Joaquin to talk about the legal aspect of this question first.
So, you know, this is a question that has been asked over the last, we're into what, 3 weeks now? It's no longer a 9-day wonder that the discovery of the Jam COVID breach or vulnerability, we should call it. My own view is that there's no Data Protection Act in force in Jamaica. And so any sort of, you know, liability by AMBER or any private company just would not exist under that act. No, it just doesn't exist. The government too, it couldn't, and some argue cannot be held accountable. I mean, when we talk about 4% of global income, what 4% are you talking about? It cannot be the consolidated fund. I saw reference to that in a person. I do not think that that is the case. That being said, though, I'm still looking out for how, especially the EU, has handled regulatory breaches by regulators and how they deal with those sorts of compromised situations. We are in Jamaica, but this app was used by non-Jamaicans, people who are Europeans or from other jurisdictions. And so arguably too, there is some remit for GDPR and the persons who are the regulators in those various countries to levy either a fine or otherwise on the Jamaican operators here. I don't think AMBER is the data controller. I think AMBER is a data processor. I think the government is a controller, and the Prime Minister did make mention of that 2 nights ago in a press conference when he spoke about the government is the one that has retained the data. I would love us and our journalists to ask more questions about that, but he has said that it's the government that controls how AMBER dealt with the data, and they're the repository of the data in the long run. So to answer your question, in summary, we don't have a law yet. I don't think there's any legal ramifications, certainly on the criminal side or civil penalties as our act prescribes. We do have a right to privacy. So who knows, someone may start up some constitutional right and ask for redress, or constitutional claim and ask for redress. But my view is that there is no local remedy for anybody who feels that their right has been breached by AMBER or the government, certainly not under our Data Protection Act.
And Grace, from the perspective of, I know it has been referred to as a data breach, right? But I think to qualify something as a breach, there has to be some kind of an investigation to determine if data was actually disclosed. So far from where I sit, I would say it as a data incident at this point, and until it is proven that data has been disclosed, it would remain as an incident as opposed to a breach. Would that be something that you, from a legal perspective, you'd agree with?
That's a funny one, because we haven't defined, to my knowledge, we haven't defined what a data breach is. We talk about accidental loss, contravention, and just data breaches. So we're going to take the dictionary definition, we're going to take the technical description and technical definition from you folks over in the technical area. I do think whether it's a data incident or data breach goes to the level of the fine involved. That's my view on how certainly the European Union has treated it. They look on the how egregious it is and how severe the breach was versus not in coming up with the level of fine, because there is some discretion on the part of the regulator in terms of what fine would be imposed. Yeah. And so I think in the long run, that's what we look at.
So breach comes from 2 perspectives, right? Breaching the security of the systems, right? And breach of data would be the disclosure of the data. So from the perspective of the systems, the systems were possibly breached, but the data, as it relates to the data protection regulations, the data, if not proven to be disclosed, and so then the data wouldn't necessarily be breached, and there may not be an obligation under any act subject to and it would be subject to investigation to determine whether or not data has been actually disclosed.
Right, got you. Thank you, Andrew, Grace, Ian, Keith. I hope that was useful. There's another question here from Ian Keith as well. And while so this question goes, can the course be done along with the regular working schedule, or will staff be required to request time off to participate? Is it self-paced or lecture contact hours? I can answer that one. It's the live in-person course is 2 days, over 2 days, and it's really comprehensive. And then there is a live online version as well, which is delivered over 5 days from 9 to 12 each day. So, there are a couple of options. I mean, all of our courses are lecture contact hours. We don't do self-paced and e-learning, just because there's just so much data and so much technical information that really requires the expertise of practitioners in this space to be able to really bring it to life. But Ian Keith, we can certainly talk a little bit about it after this webinar and send a little bit more information to you around how the courses are delivered. There is another one from Tariq. It says, is there any laws or section of the law that mandates that a data custodian or manager must reside within your company once your company handles personal information? Joaquin, I don't know if you want to take that one.
Sure. Okay, so let me just look back at the question. I think we just need to clarify one thing in relation to the legislation. When we talk about a data controller, we're actually not talking, well, we're talking about two probably groups of persons. We're talking about an individual who in their sole trade or practice or firm or whatever is processing personal data. And then we're talking about legal personality or legal persons who accompany, public authorities that would be defined in the legislation. So we're talking about either an individual or an entity. We're not talking about individuals within the entity. And so the legislation focuses on what that organization, I'm going to use the word organization, whether public or private, how they process the data. It's not individuals within the organization that is the focus of the legislation. It's the organization itself. And to the extent that the person who is processing is an individual, then it is applicable to them. So that what the legislation is applicable to data controllers that reside in Jamaica and the word that the legislation uses, established in Jamaica or anywhere that Jamaican law applies. So if you think about our high commissions outside of our that are posts or established in other jurisdictions, then the law would apply. But if you're a data control, if you're a controller who, that is not established in Jamaica, but you use equipment locally to process, then the legislation is applicable. Additionally, the legislation has what we call an extraterritorial aspect of it, in that even if you're not established in Jamaica, but you are offering goods or services, whether for a fee or free, to Jamaicans or individuals in Jamaica, or you're monitoring their behavior in Jamaica, then the legislation is applicable to you. And just to point out that that bit of it was an amendment that would have been made to the 2017 bill to allow for what persons call to be more aligned to what happens with the GDPR now, where it takes on almost like this extraterritorial life. So I'm hoping that was response would have answered the question, that it's not about the individual within the organization, but the organization itself.
Got you. Great. Thank you. And we're out of time, but we just have time for one more question before we share the results from the poll and just talk about the special pricing that we have for public sector employees. So the question is, are there regulations drafted in relation to the Act? And I guess Joaquin,
yeah.
Can you take that one again?
Right. So we're in the process now. There are some pieces of regulations that will fall within the remit of the commissioner, him or herself, and those that fall within the remit of the minister. So we're now in the process of assessing, and would have already actually assessed the regulations that are required immediately upon implementation. And so over the next year or so, we'll be working assiduously to have those regulations that we consider critical to the successful implementation of the legislation in place.
Good. I'm glad for that response, because that's a question that we get a lot. That was actually a really good question. We get that question quite a lot. So I'm actually really happy that you're able to provide that clarity. Thank you very much. DeAndre, would you mind sharing the results from our poll questions on screen? So in terms of the questions, is, I remind you again, is your organization prepared for the Jamaica Data Protection Act? 7% said yes, 41% said no, 38% said we have started preparing for the regulations, 14% said we have yet to start preparing for the regulation. The second question, does your organization have a data privacy officer or someone qualified to act in the role? 34% said yes, 62% said no, and 3% said we are seeking to hire as we speak. And the third and final question was, has your organization ever performed a privacy impact assessment? 7% said yes, and 93% said no. So the results from these questions indicate that we still have quite a bit of work to do as it relates to getting our house in order, so that we are compliant with the act when it comes into effect. And one of the things that we've been doing at Symptai Consulting, as we've mentioned before, is we've been working a lot with organizations, really just to help get them ready for the act. And we do that through our privacy training courses. And Andrew talked about the CIPM course, the CIPT, and the CIPP. We have two coming up: the Certified Information Privacy Manager, CIPM, on the 15th of March. So that's March 15th to 19th, and that's live online. That will be from 9 a.m. to 12 p.m. daily. And the instructors, Grace is one of our trainers, Andrew Nooks and Daniel Monroe, who's not a part of the panel, but a panel of really exceptional trainers. And then there is a Certified Information Privacy Technologist course, which runs from March 25th to 26th. That's a 2-day in-person training course with all of the COVID-19 protocols observed. We're offering a special discount for public sector employees. We do understand that public sector will have to be at the forefront of compliance, simply because this is coming from the government. So to play our part, we have created a special discounted package for public sector organizations. So do get in touch to find out a little bit more. You can register on our website at www.symptai.com/training courses, or you can send us an email at training@symptai.com, or you can reach out directly to myself, Andre_Palmer@symptai.com for more information. Again, thank you very much for participating. We've gone a little bit over time, but you've stayed. We still have over 70 people. So it means that you found the conversation really useful and informative and insightful. So thank you very much for attending and for staying. Thank you also to Grace, to Joaquin, and to Andrew. I could listen to all of you all day long. I mean, your knowledge and insight has been really remarkable in this conversation today. Thank you very much again. And thanks to DeAndre and the marketing team for executing this webinar. Thank you, and enjoy the rest of your day.
Thanks, everyone.